Hi all, I'm Harv Nagra, and welcome back to the Handbook, the Operations Podcast. When I worked as a group ops director at an agency, it was tricky enough navigating the IP, intellectual property conversations with clients. Who owns what? What happens when they suddenly want source files? Do you hand them over? Do you charge for them? Do you point to your terms and conditions and just say no? It was already a sensitive area, but in the era of AI, it's become even murkier. We've got human-created work, AI-assisted work, AI-generated work, and not a lot of clarity on where ownership actually lands. But it's not just about IP. As agency and consulting firms weave AI into audits, strategy work, creative, and delivery, there are bigger questions too, around data privacy, confidentiality, accuracy, bias, and even what happens when an AI-assisted recommendation turns out to be wrong. And when a lot of us are still working out how to operationalize AI into our ways of working, it's easy to focus on the upside and forget that it comes with a very real set of risks for us and for our clients. So today we're tackling the legal side of all this. How to think about IP in a world where humans and machines are both contributing to your work, and how to reduce the wider risks that come with using AI inside your agency or consultancy. To help us do that, I'm joined by someone who's an authority on this topic, Sharon Toerek. She advises agencies and consultancies every day on IP ownership, contracts, compliance, and more recently, the fast-evolving legal questions surrounding AI. She's written extensively about how businesses can reduce their AI risk exposure, how contracts should evolve, and what leaders need to put into place to protect their teams and their clients. This is a big conversation today, and genuinely one of the most important topics agencies and consultancies should be thinking about right now. So let's get into it. Thanks for listening to the Handbook, the Operations Podcast. This podcast is brought to you by Scoro. If you're in ops right now, AI is probably a huge part of your day. ChatGPT, Claude, Gemini, and now there's MCP, Model Context Protocol, which lets those AI tools securely connect to your systems and actually do things, not just answer questions about them. That's exciting. It means your AI can start acting like a control center, pulling data, spotting risks, creating tasks, updating systems. But here's the catch. AI is only as useful as the systems it's plugged into. If your data is scattered across a dozen tools, spreadsheets, and workarounds, you're just automating confusion. Scoro is different. It's a modern PSA designed to be the system of record for professional services businesses. From pipeline to projects to resourcing, billing, and reporting. One place where the data actually makes sense. And now, with Scoro's MCP server, you can connect that single source of truth directly into your AI workflows. Summarize meetings and log actions, pull live project data and flag risks, draft updates, create tasks, and keep work moving without jumping between tools. AI doesn't replace your PSA. It makes a good one dramatically more powerful. Go to Scoro.com/demo to learn how Scoro is helping ops teams work smarter in the age of AI. And for the VIP treatment, tell them Harv sent you. Now, let's get to the podcast. Sharon, welcome to the podcast. Thank you so much for being here.
It's my pleasure, Harv. I'm looking forward to talking with you today.
Sharon, before we get into AI, and we're going to spend a lot of time talking about that today, I wanted to start with IP in agencies more generally, because I used to work in an agency and face this issue. And I'm sure there's other listeners listening that face this issue. So this kind of confusion around ownership that comes up sometimes, particularly the idea that clients own the final deliverables that are produced, but the editable working files are owned by the agency, which can lead to awkward conversations when clients ask for them later. So my question first is, at a high level, is that still the typical default position?
It is still a typical default position, and it's really only one of what we see is the most frequently arising issues, or are the most frequently arising issues with IP. The second is a lot of agencies, a lot of consultancies, they create their own proprietary IP, and there's never any intention that
Right.
that proprietary stuff become part of the deliverable work for hire from an IP ownership perspective. So the example you cite, which is, do we have rights just to the final delivered work versus the source files and all the working files that led up to that? And also, if the work you've delivered to us, consultancy or agency, has some of your proprietary IP in it, what is our position as a client to that stuff. And so those are the two issues we see most frequently. And I think they arise with about equal frequency with consultancies as well, because the IP issues are almost identical when it comes to the work product and the client's interest in owning the rights to it.
From your experience, what is the right way for a business to handle that conversation? It's one thing, I think, when it comes up during the quoting stage where you're kind of
Yeah.
preparing the proposal. But separately, when it comes up after the work has already been delivered, I think it's even trickier sometimes. So, what would you recommend in those scenarios?
Right. From a pure legal perspective, it's not hard to document an adjustment in the parties' understanding around final deliverables only versus original files and working files. From a practical and financial standpoint, what we usually see is if the parties haven't had a conversation up front, setting expectations, the agency or the consultancy usually has to think about what the cost of doing that work of assembling the files, transferring them over, making sure they're in workable, usable condition, and what an equitable way to recover its costs for doing that would be with the client. And so
Mhm.
you'll see sometimes an administrative or a file gathering charge of sorts. The other thing, and this is not really a legal consideration, this is more of a business relationship consideration, is how far do you want to push this? This is a client with whom you have a good relationship and you want to keep the doors open to future projects,
Right.
future business opportunities, the need for testimonials, all of it. And honestly, what is the true burden to the agency or that consultancy to actually put the stuff together? But to your point, originally, it's much easier to have the conversation up front and to be explicit. You can always change your mind later if you decide to do that, but to be explicit in your language and also in your contract terms about what they're actually obtaining the rights to. What's a work for hire? What's
Mhm.
only licensed to you as the client? And how do you handle alterations to that relationship?
I think the idea sometimes might be when you're commissioned for a campaign or you win a pitch that you're going to get repeat business from this campaign
Yeah.
or this client. So when you release the files, obviously they can hand them over to their in-house team or to another business to continue the work. So that's where I think
Yeah.
some of the trickiness also comes up from a business perspective.
Agreed. And so this is, look, I am an IP warrior. That's how I really made my way to creating a firm that serves a creative industry, is because I believe in the power of IP and that it is important and it is property and you do need to protect it. I think we're starting to see a little bit more movement towards the idea that agencies or creative partners or consultancies should share in the upside in different ways than they have traditionally done. And that means figuring out a revenue formula that will compensate the creator on an ongoing basis based on the success of the buyer, the brand, the client using the work that's been created for them. I will say it's still a minority practice between creative agencies and probably consultancies and their clients, but we're seeing more and more conversations, particularly between independent agencies and brands that might be enterprises, but they're willing to think more entrepreneurially about the
Right.
value of the work and the creativity that's being provided to them. So I hope we'll see more movement in that direction. And certainly the legal terms and contracts will have to catch up to that, but it's still minority practice for most agencies in my experience.
Really good point. We're going to get into AI risks. The way agencies and consultancies use AI does overlap in a lot of ways, but also differs in terms of the outputs that are created. So I wanted to
Right.
start off by outlining some of the risks for these groups separately first, if that's okay. So if we
Sure.
start with consulting firms, they might be producing audits, insight strategies, working on implementation of these strategies. I think there was a recent example of Deloitte having an AI scandal where they were caught fabricating data and having other errors in something like a 440, what was it, $400,000 project for the Australian government. So, can you talk us through some of the risks for consulting firms?
I think the risks on the consulting side basically are born out of the practice of taking shortcuts where you shouldn't be. AI is not an excuse for substituting human judgment, human insight, particularly in the consulting realm, you're being engaged by a client to help them solve a business problem or help them take advantage of a business opportunity. And ultimately, what they sell is either sold to a human, an individual consumer, or a buyer for an enterprise. So the same negligence principles, the same due diligence principles, the same accuracy
Right.
principles apply whether or not you're using AI. AI is just creating more real estate for trouble to occur
Mm,
because it's very tempting to take shortcuts. And it's easy to forget that the machines have not caught up with humans when it comes to judgment, when it comes to insight, when it comes to expertise and context, right? Consultants are engaged because they've done a body of work or are exposed to data and experiences that help them be able to be strategic advisors to their clients. And
right.
so if you're putting reporting out there or strategy out there or making recommendations to your clients that are born out, right? Garbage in, garbage out, that are based on shortcuts because AI has made it easier to do so. You're not going to be any less responsible, any less liable for those mistakes, for those shortcuts than you would be if you had used some other technology to create the work product.
Absolutely. The hallucination thing is still a real risk. And kind of the
Yeah,
reputational damage that can arise from something like that is
right.
just maybe just a warning.
100%. Yeah, and law firms are not immune. We've had a number of cases of law firms stupidly, and that's my word, you submitting briefs to the court or doing research and not verifying the results of the research on AI. And hallucinations popped up, citing cases that don't exist or citing them for propositions that they don't support. It's the legal industry, the accounting industry, the consulting industry, and certainly creative services field. None of us are immune to that. We still have to remember that we're standing by the advice and the work product that we're delivering to our clients. And AI is just a tool. It's not a responsibility
Mhm.
eliminator. And it doesn't make us any less liable or responsible for turning out work product that is helpful to our clients and meets the terms of that we've agreed to with them.
Absolutely. Let's talk about agencies and risks for them.
I think the top two risks for agencies, whether they're creative or media or digital, whatever their discipline, are the IP questions because I don't think the parties are really thinking about at the outset the ownership position. They want the benefits of integrating AI into the workflow. They want to be cutting edge in terms of the tools that they're using. They want any cost savings that are achievable, and those are minimal right now, but they won't continue to be. They will be more meaningful as time goes on, in my view. And so they're not thinking about, well, who's going to own this stuff at the end of the day. So the answer right now, in certainly in the United States and in Europe and in most of the world, is that you can't own the rights to anything this machine created. And
Right.
so the question then becomes, what if you incorporate AI generated work product into the deliverables? What's the ownership position there? What are the liabilities and responsibilities for it? And the truth is, you can only own what the humans have created. So
Right.
everybody's taking a risk that the contributions to the final deliverable that are AI generated are not material enough to have to worry about IP ownership in, or that they're going to treat it just the way they're going to treat any other third party work that gets incorporated, like a stock photography image or a piece of software that gets incorporated. Um, Part B of that problem slash question is, what if something goes sideways? What if the
Right.
work gets delivered, gets deployed out into the market, and there's some incorrect claim? There's backlash because an image has five fingers where it's supposed to only show two, or whatever it might be. Who's going to be responsible for that? And so that's not really an IP question, it's more of a liability question. But the simple pathway here on IP when AI is involved is if a human didn't create it, um, then it's not ownable either by the brand or by the consultancy or by the agency. And you just have to decide how much that matters based upon the purpose of the work and who's going to see it and how it's going to be used and deployed. And then the other thing to keep in mind is that every platform, every AI platform that's engaged to create generative AI produced work has got its own terms and conditions. They're mostly fine with you owning the end product as a result of using their platforms. They're just not going to help you if there's some infringement that happens out in the world or indemnify you, even if it comes as a result of using the AI platform. So those are issues that I tend to spend time worrying about a little bit more than the actual IP ownership of the deliverable. But you have to handle it in your contract language. You have to handle it by having upfront conversations with the
Mhm.
client about it and make sure it's not a detail swept aside until later in
Absolutely.
the relationship.
Right.
The second risk pool really is handling manipulation of data. And that's for a couple of reasons. First of all, it relates to making sure that you are keeping sacred, if you will, the confidentiality of any sensitive or proprietary information that the client has that it's putting in your hands so you can do your job for them. But secondly, there are consumer privacy laws, data privacy laws, especially in Europe. And in the United States, we don't have a national standard for data privacy, but we have this patchwork of state laws, California being the most restrictive, although Maryland's starting to give it a run for its money with their new law. So, data privacy, compliance, confidentiality of sensitive data, that those questions are top of mind when it comes to risks for agencies because agencies are handling this data and information every day and they are creating original deliverables. And so the IP questions that we've talked about. So those are issues top of mind for me and for my legal team when we're counseling clients that they need to be aware of. There are other issues that don't probably occur quite as often, and that can be reputational risk associated with product that is either inaccurate or distasteful or whatever and doesn't make it through enough scrutiny, or making claims in advertising that aren't supportable or sustainable based on facts that AI has generated that are wrong.
Sure.
But those tend to pop up less. And I'm right now, today, as we're having this conversation, I'm a little less worried about all of those for agencies than I am about the IP questions and the data management questions.
Sure. And in talking about this for both these groups, I just realized how much overlap there is. Really, all of this applies to either kind of business, agency, or consultancy. Even the examples we're citing, a lot of them. So you've developed kind of an AI ready workplace framework. It's got 5 steps. I was looking over it. I'd love for you to walk us through what those steps are.
Yeah, I'd be happy to. The first part of the framework is key conversations, making certain that early in the relationship with your client or your prospective client, that everybody's talking about how AI is going to fit in to the work or the relationship. What are the expectations of the client, the brand around it? What do they need to know, want to know? What do they forbid? What do they require? Because a lot of enterprises are still, they've got very conservative policies still around AI usage. And anybody who's serving them needs to know what those are and work within those swim lanes so that they're not
Mhm.
violating those policies. So it's having conversations with your clients. It's having conversations with your vendors and your strategic partners. What's their risk tolerance for AI? What are they doing? What are they using? Both tools and use cases. How are they using it? And what tools are they using? And what are their practices in terms of maintaining data integrity and disclosing when they've used AI to create a deliverable? Um, your freelancers, you certainly need to be having conversations with those parties so that they understand if your client has restrictions that might apply to the work they're going to do for you. Your team members, obviously, the people who work with you, you need to be having robust conversations internally, doing training, whether formal or informal, and communicating with clarity as a leader of one of these organizations to your team. What's our risk tolerance for using AI? What do we talk to clients about? What do we need to know from clients? And where are the human guardrails, right? If we want to use a new tool, if we want to make a new use case recommendation. So having those critical conversations, that is step one.
So on that, I think what's important to highlight is that you're saying it's not sufficient just to have your terms and conditions outline how you anticipate using AI or how you plan on it, you need to have these conversations just to make sure. And again, that example of kind of enterprise clients having very strict guidelines or policies of their own is an important one to highlight.
Yeah,
Yeah.
and I think that where you don't want to find yourself is midway through creating the work or doing the research or developing the strategy and then hitting a roadblock or worse, having to undo and redo because there's some policy or prohibition or cultural objection on the client side to the way you're using AI. You don't want to find those things out later. You
Absolutely.
want to know those things up front. So crucial conversations.
Yeah. And two other examples that you gave there, talking to your team and talking to freelancers and contractors, I think such an important point. And I think that is actually something that is quite easy to fall through the cracks. Maybe the accounts team or the project delivery team has had conversations with the clients on all of the stuff at kickoff or at the planning stage of the proposal, but making sure the rest of your team knows. Because if all these policies are in place and these are the client's restrictions and nobody else is told that, then that opens you up to significant risk.
Yeah. And I think it should be something you just ingrain in your either onboarding with the client or your onboarding of the freelancer or the strategic partner or the vendor. These
Mhm.
just be a standard part of your vetting process and your onboarding process when you're working with these parties. And it should be a regular part of your internal team education and training.
Absolutely. Let's move on to step two. So tell us about that.
Step two is somewhat related and is developing written policies around AI use. And these are going to be dynamic. They're not going to look the same 6 months from now as they look today. But I think that every agency and consulting firm too should have a written articulation of its policy around using AI. And you might need two. You probably need one that is outside facing that helps clients, vendors, other partners understand your policy and position around using AI. And then you may need one internally that's a little bit more detailed, a little bit more process and procedure in addition to policy. But having written policy and regarding it as a living, breathing thing that needs to be dynamic and updated as practices are updated is the second sort of plank. And it can be a trigger for those conversations that you're going to have that we just talked about.
So, what happens in that scenario that we were talking about a few minutes ago? Let's say you have a designer that uses Midjourney or something like that without permission or doesn't know any better. A strategist uses ChatGPT to analyze client data without permission. You have a subcontractor that relies on AI generated content. And this has happened and it's found to be infringing. How would you navigate that kind of situation?
If you know it's infringing before it's released to the client, then fortunately and unfortunately, you haven't caused harm to the client yet because it hasn't made it out into the world, but you've
Mhm.
cost yourself a lot of money because you're going to have to redo the work, most likely. Sacrifice the part of it that might be causing the potential issue. If it's released out into the world and it's caused some sideways effect as a result, like there was an infringement of somebody else's original work that nobody knew about, it objectionable for some way or opens up the client to some responsibility or liability. Those are issues you handle just like any other error or omission that an agency might make. This is an example of you just having additional tools in real estate, frankly, to get in trouble with. And
Mm.
so those are handled the same way. What concerns me and the reason why I think the risks are deeper is that the speed with which the tools can be employed makes them look simple, easy, and less risky than they actually might be. And slowing down is not something that is a favorite behavior,
No.
creative firms. In my experience, faster, better, bigger, taking that beat to sort of assess before you put work out into the world, whether it's to your client or out into the public market, is something that we're going to have to think harder about when we're tempted to move faster because AI makes things faster. This is something that can also be reflected in your policies. What are your work review and approval sort of measures? And what's the client responsible for? what's the agency or the consultancy responsible for before the work goes out into the world.
Absolutely. Excellent. Let's move into step 3 then.
Spend some time reviewing the terms and conditions of the platforms that you use. And this sounds silly and basic, but most AI platforms have created different levels of access now. And so you need to know which level of access do you have? What kind of an account do you have with these platforms? Because there may be different terms and conditions, and the platforms are starting to dabble in taking on a little bit more responsibility for indemnification and liability. If you access them at, say, an enterprise level or a paid level, than if you just use the basic free for everyone versions. And so know the terms and conditions. I can give you a spoiler alert and say that in almost every case, the platforms are fine with you owning the IP to the output from AI. They're just not going to protect you if something goes wrong in the world as a result of you using output from AI. Read the terms and conditions of the platforms that you use, understand the kinds of licenses and accounts that you have so that you can speak fluently about who's responsible for what platform versus creator.
Absolutely. Really good point. And I don't think that's silly at all, because we have a tendency to click agree on those terms and conditions and not bother looking at them, in fact. But in this kind of business context,
Yeah.
using this kind of technology, I think you've just really highlighted some of the reasons we have to be really careful. And good point about the different plan tiers having completely different terms and conditions sometimes.
Yeah. And this is, again, this is not the sexy part of the business for either a consultancy or an agency. Nobody wants to read a software license or a platform license, but the ones you use most frequently, start there, right? Be aware of the differences between an enterprise level account and just a basic free access account and what it might mean when you use those tools, and understand which versions of the tools your team is, are they working at home on the weekend in their personal accounts when you need them to only be working in the enterprise accounts? So
Good
this is why
point.
taking some time to look at the terms and conditions of the platforms you're using is important and meaningful.
Excellent. On to step 4 then.
Step 4 is your contract language is important to think about. We have completely retooled our approach in client service agreements for agencies at the firm. We used to treat it in the beginning, Harv, 2 years ago, when before ChatGPT make this all very democratic, we used to treat it like any other third party work, but now it's really worthy of calling out in its own set of terms and conditions. Who's responsible for approving the work before it goes out in the world? Who's responsible for complying? Who is responsible for addressing problems as they occur? So having specific contract language with your clients, with your contractors and your strategic partners that line up the responsibilities with the right parties, that is, I think, a crucial step, because this is sort of a new frontier and things we hadn't thought about before, we're needing to think about now. And if we don't catch them in the conversations, if we don't catch them in policies, then we need to catch them in our contracts with our clients so that we have some written expression of our understanding about who's responsible for what and who will solve problems if they occur.
Step 4 then.
Step 5. We're on step 5, and that
Step 5,
is,
sorry.
yeah. That is, you've got to be cautious when you're inputting your client information into any AI platform, and you've got to be super extra particularly cautious if you are going to be inputting any consumer data. Everybody who touches the data, who manipulates it or processes it, is going to have some responsibility in the liability chain when it comes to violating a data privacy regulation. That's true GDPR. It's true in the United States, primarily because it's true according to the state of California's rules and the state of Maryland's rules. And you have to really be thoughtful about what information you're going to be using in your prompts and what the client's position is regarding the confidentiality or the sensitivity of that data. And then choose your platforms and your level of access. Closed systems versus open systems are very important to distinguish between, because you want to
Mhm.
know whether the platform you're using is going to be training on any data that you input. And then you need to know your client's policies around protection and use of that information. So it's not only data privacy law regulations and compliance with those, but it is your client's own particular preferences and the confidentiality and non-disclosure terms you might be subject to as a result of working with them. So proceed with caution when inputting any client or consumer information. That's step 5.
Really good point. So, Sharon, we've been talking about different jurisdictions. You mentioned GDPR, you mentioned California. Businesses that work internationally might be exposed to laws in a lot of different places. Are there any major differences listeners need to be aware of, perhaps between the US versus the UK or the EU?
GDPR is a more global approach agreed upon by the member nations of the EU who have harmonized and come to a mutual agreement about how they're going to enforce data privacy. It's also the standards are gold standard when it comes to strictness and privacy. The United States is a little bit looser constructs because we don't have a federal standard. And there hasn't been any agreement yet on what the federal standard would look like, whether it be more strict, like GDPR or like the California statute is, or whether it be more permissive. So you have to play to the strictest standard, we always tell
Mhm.
our clients. And the second thing we would say to any client would be it's not about where you are, it's not about where your client is geographically, it's not even about the markets that they target. If one single consumer in that database or on that email list or in that lookalike audience on a social campaign is in a jurisdiction that is governed by GDPR or the California Consumer Privacy Act, you're subject to that law. It doesn't matter if you didn't mean to be. It doesn't matter if you even don't care about selling to somebody who lives in California
Mhm.
or Germany. It just is. This is the way the law works. And so we play to the strictest standard. And that's always our advice. And to me, and the way we advise clients, it doesn't matter what the differences are because we want them to be as compliant as they can be with the highest level of privacy governance that they can afford. But in general, to answer your question specifically, the European standard is still a little bit more protective of individual privacy, data rights, and I think the enforcement mechanisms are necessarily more stringent because you have a unified standard and there's been more time and energy put around enforcing it as a group. Whereas in the United States, like I've said, we're still a patchwork here of regional rules about data privacy.
So that has to do with kind of data privacy risks with using AI and getting it to analyze your data. When it comes to AI regulation, I suppose the main thing that I've heard people talk about is around this kind of IP law. Any differences there you can point to between the different regions?
Not significantly at this point. I will say that the European market has a long legacy of enforcing moral rights in intellectual property, so that even where there aren't statutory rights to trademark or copyright, a creator has there's a long history there of enforcing moral rights. And that will impact, I think, the way that AI generated work probably gets protected or that infringements get handled versus in the United States where we have, frankly, for lots of reasons, legal, geopolitical, and other, we have a tension between the states wanting to step up in some cases, New York, California, and enforce AI specific things like use of synthetic performers, making disclosures when AI has been used to create a piece of work. But there's no unification to an approach, and there's actually a bit of tension between our federal system and our state system about how we're going to regulate it. And so, from an IP perspective, my prediction is that, at least in the United States, we're going to see more movement towards these licensing arrangements like the one that Disney just made with OpenAI. I saw that coming. I didn't see the equity stake part of it coming, but I think we'll see that globally. But I think that Europe will be slower to step away from strict enforcement of
Sure.
creator rights. And I think they'll hold on to those protections probably a little bit more tightly than the American market might.
Makes sense. So, Sharon, we've covered a lot of ground there, but with this kind of context that you've given us today, what are two or three things that you think that agencies or consultancies should put in place over, let's say, the next 90 days to protect themselves if they don't already have some of this stuff in place?
Yeah, I think three things. First, get with your teams and create a conversation checklist. This is something a consultancy or an agency of any size can do. What are the questions we need to be asking our clients, or what are the things we need to be saying to the client when we are talking with them in early stages about taking them on or taking on a new project for them if they're an existing client? So, creating those conversation checklists, do some brainstorming about what you need to know and why you need to know it, and think about your talking points. So, that would be step one, very scalable and simple to implement. Step two, have a written AI policy. If you're not sure what to say to clients yet about AI, start internally. Have an
Mm,
internal policy around how you're going to use it. Don't expect your first pass at it to be great or permanent, because it's going to need to be fluid and dynamic and updated as the tools change. And then third, take some time looking at your service agreements and determine whether it's right for you to add specific language around how you're going to be using AI to serve the client. So those are
mm.
the top three things that I think an agency or a consultancy of any size can do. And they somewhat relate to one another, so they're kind of synergistic in that respect.
Absolutely. Fantastic advice. I think you're right. There's a lot of excitement around these tools, and we can see that. We've had conversations on the podcast with people doing really innovative things with AI, but it's just so important that we're protecting ourselves. And that's an operation director's, COO's
Yeah,
responsibility to make sure this stuff is in place. So I hope this conversation has been really helpful for our audience. I know it has been for me. So thank you again for joining us today.
my pleasure, Harv. Thanks for having me.
Before we wrap up, I wanted to share a few of my own takeaways from this conversation. The first is that a lot of the AI risk we talked about today isn't actually new. It's an amplification of the risks that have always existed: IP ownership, confidentiality, accuracy, liability. AI just makes it easier to move faster, and in doing so, easier to get in trouble if the guardrails aren't there. Second is that none of this is about saying don't use AI. In fact, the opposite. What Sharon really reinforced for me is that agencies and consultancies should be using these tools, but in a way that's deliberate, transparent, and operationalized. Conversations up front, clear policies, clear contracts, and making sure your team, your freelancers, and partners all understand where the lines are. And the final takeaway, especially for anyone in ops or leadership, is that this is now part of the job. AI governance isn't a future problem or a legal edge case, it's an operational responsibility. If something goes wrong, it's not the tool that gets blamed, it's the business. If you've been experimenting with AI without formalizing how it fits into your ways of working, this episode is your nudge to slow down just enough to put some structure in place. Now, if you've enjoyed today's episode, please share the episode with someone that would appreciate it. That's it for me this week. Thanks very much for joining us. This podcast is brought to you by Scoro, a platform designed for agencies and consultancies which allows you to manage your projects, finances, and resources, all from one system. This is a platform I brought in at a previous workplace which completely transformed the way we worked and which I've recommended to clients of my own. You can sign up for a free trial on Scoro.com. That's SCORO.com. Or reach out to me, Harv Nagra, on LinkedIn if you'd like to hear about some of my experiences.